Good afternoon, ABA Division for Public Education Twitter followers. Thank you for joining us. I am, as always, pleased to be joined by Professor Stephen D. Schwinn of the UIC John Marshall School of Law. Professor Schwinn, thank you once again.
Thanks, Kathy, for having me.
And today we're going to sort of broaden our scope a little bit in our discussion lens outside the borders of the United States, while still talking about the U.S. Supreme Court, and wade into some cases that are coming up in the next 2 weeks, dealing with some international human rights issues, some civil procedure issues, and asks the court to really tackle some broad cases beyond what it normally gets into. And Professor Schwinn, I know this is one of your area of expertise normally. Can you just give us a quick overview of how the court normally deals with some of these issues?
Yeah, so all of these cases, we have 3 cases in the next couple of weeks, and they all deal with different aspects of enforcement of international human rights in the US courts through different statutory mechanisms that we'll talk about here in a second. But what we've seen historically, at least in the recent history of the Supreme Court, is a kind of narrowing of the window. In fact, a pretty substantial narrowing of the window of allowable international human rights claims in the US courts. The Supreme Court really has shied away from these claims. We see them under the Alien Tort Claims Act as one sort of approach, the Alien Tort Statute or Alien Tort Claims Act, and the Foreign Sovereign Immunities Act is the other approach. And so, Kathy, I wanted to ask you about this Nestle case that comes up under the Claims Act. Can you talk a little bit about that?
Thanks, Steve. That was a helpful way to place it with this idea of the narrowing the window, because I think this Nestle case is a great example of sort of how the window's been narrowing, and really ask the court to answer the question of whether or not the window's even open anymore. So this case, it's 2 cases actually that have been combined and consolidated for oral argument at once: Nestle USA versus Doe and Cargill versus Doe. We're going to hear them on December 1st. And I had a professor out of the University of Texas at Austin, Linda Molnex, who writes a lot of these civil procedure cases for me. And when she sent the article for me for ABA Preview on this case, her comment was, if you read the briefs, you're never going to want to have hot chocolate again. And so these sets of cases come out of some pretty terrible allegations out of some cocoa farms in the Ivory Coast. So Nestle is our big chocolate producer one of the big chocolate producers in the US, one big hot chocolate producers also. And the allegation is that there's these farms in the Ivory Coast that Nestle does not own, does not run, does not control, but has a relationship with. And that's some of the question for the court to get into. But on these farms, the plaintiffs represent child slaves who were forced into labor on these farms, just under terrible, awful, horrible conditions, malnourished, beaten, kept away from their families, just terrible, terrible conditions. So the plaintiffs sued these 2 American companies under, as you mentioned, the Alien Tort Statute, the ATS. And they want to hold these American companies liable for the actions of the farmers on the Ivory Coast. They claim that they were aiding and abetting the slave labor. As I mentioned, the corporations did not own these farms. They did purchase the cocoa from these farms. And there is some allegations that the American companies gave what they called spending money to the farmers who ran the farms. They were sued in federal court in California about 15 years ago, and this case has had a long, long history before the federal courts, going up and down a few times, in large part because of, as you mentioned, that window that's been narrowing and before the Supreme Court. And there's 2 important cases that happened that the court issued during that 15-year time: Koibel versus Royal Dutch, and then Jessner versus Arab Bank. So I'm going to back up just a minute and talk about what the Alien Tort Statute says, because I think that's important. And so it gives a federal district court jurisdiction over crimes that are committed in violation of the law of nations, excuse me. So that's sort of why we're under this statute. We're claiming that child slavery, enforced labor violates the law of nations. And so in theory, the California federal court should have had jurisdiction over these cases. So that's sort of the lay of the land that gets us here. Koibel, however, was a case from 2013. And in that, the court held that the ATS has to follow the normal presumption against extraterritoriality. So normally, US federal laws don't apply outside of the US land, and that's the presumption. And so in what the court was saying here was that ATS is the same as every other federal law. We're not gonna go against this presumption automatically, that you have to make more of a showing. And it created this touch and concerned standard. Although it wasn't really a standard, it just sort of came out of the language of the decision. So that's one issue, is sort of, does the action of Nestle in the Ivory Coast, is that enough to satisfy this touch and concern standard? The second case that I think is important here is this Jessner case, which involved the Arab Bank, which was chartered in Jordan, founded in Jordan, but chartered in New York, very much a foreign bank, but had American offices and actions, and they were accused of funding terrorism in the Middle East and of some bombings in Israel. So the victims of the bombings and their families sued the bank, and the court in Jessner said it's a foreign company. ATS does not apply to foreign companies. So what the court's being asked here is sort of, what are the nuances of Koibel and Jessner? So is it the touch and the concern, and does it apply to domestic companies? That Nestle and Cargill are domestic companies. So does Jessner go one step further? Because the justices there were not, some of the justices would have gone further in Jessner. There wasn't enough of a plurality vote to get to the domestic aspect of Jessner. So that's really what the court's being asked to do here, is apply these two precedents that have been ongoing for quite some time in this developing way of how we're applying or limiting the application of the ATS. And what does that mean for these plaintiffs?
Sorry,
That's
muted
okay.
myself. Do you have any? So I guess a couple of things. Do you have any thoughts about the way this court is going to approach these questions? And importantly, now that we have Justice Amy Coney Barrett replacing Justice Ginsburg, do you see a shift in the court's dynamics with that change with regard to ATS claims?
Yeah, I think that's a great question. My inclination is that this is probably going to be the next step after Jessner. I think the Jessner decision, it was a Justice Kennedy decision, so that obviously has changed. But he focused a lot on separation of powers, leaving foreign relations to the executive branch, Congress being the one to expand statutes. And I think that falls in line with where we've seen this court going recently. I also think, Jessner was a case that went along more traditional ideological lines, 5-4 conservative liberal split. This is a case, even the briefing has fallen along fairly traditional conservative liberal splits when it comes to the amicus briefs. I envision this being one where maybe Justice Roberts is in play, although it's a separation of powers and he tends to be an institutionalist when it comes to some of those things. I don't see any major surprises for me coming out of where the justices may play out in this.
Yeah, I think that's probably right. The case, factually, it presents some interesting issues. Here you have domestic corporations that, by the plaintiff's reckoning, are calling the shots within the U.S., which is that sort of domestic connection that the court seems to demand in these ATS cases. And yet, nevertheless, for a tort that occurs in the Ivory Coast, that really is a horrific thing, right? And so that played against the background that you described, I think, creates some really sort of interesting factual problems for the court.
Yeah, I think that's a fantastic point. I think the fact that the corporations spent a lot of time sort of saying, like, everything's here, everything's in the U.S. We're headquartered in the U.S. All the people who make the decisions are in the U.S. almost create that maybe is why ATS could apply to them, because they are a domestic corporation and it's not a foreign corporation. Although I will see where the court actually plays out on that. But I think this is one where because they're saying they were all here, well, then the umbrella of the federal law can be over them.
Can be over them. I think that's exactly right. And so you may not have the same sort of extraterritoriality problem that you had in the earlier cases.
Yeah. Steve, can you talk to us a little bit about the cases we're going to hear the following week that deal with much different issues, but also present some really interesting questions for the court to deal with when it comes to discussions of foreign policy and separation of powers, and how far the arm of the U.S. judicial system can reach?
Kathy, these are just fascinating cases and deeply troubling. And they fall in line with this question about to what degree can we enforce international human rights domestically in the US courts, but they fall under a different statute. It's called the Foreign Sovereign Immunities Act, the FSIA. And as a general matter, what that act says is that foreign sovereigns are immune from suit in the United States courts. But there are important exceptions. So one of these exceptions is the expropriation exception. The expropriation exception says that a government's taking of property can be litigated in the US courts, irrespective of the FSIA's general rule of immunity, if the taking was in violation of international law. So we've got two cases that are similar, but factually different enough. I think it's worth talking about them separately. The Hungarian case, where you had Hungarian authorities taking property of victims of the Hungarian Holocaust as they were putting these victims onto transport trains into the concentration camps, totally taking their property. In the German case, what you had is a somewhat different factual situation. You had this conglomerate of German art collectors who had gotten together to purchase some really valuable art and artifacts called the Weltschatz. And so they purchased this, they held on to it, and then they claimed later that they were forced to sell it at well below market price to the Nazis in Germany as part of the Nazis' collection stealing of art. And so you've got two very different factual claims, but they both raise some core issues here. So first off, both cases raise the question of whether the US courts ought to abstain from even hearing this kind of case under a kind of international common law doctrine of comity that says that US courts ought to abstain from hearing cases that are better heard in foreign nations, foreign tribunals. And the argument is, well, these cases really are better heard in Hungary and in Germany, and so therefore the US courts ought to abstain from hearing them under principles of comity. It turns out that the plaintiffs in the Hungarian case never sued in Hungary, and so they didn't try. They say that those judicial relief would be ineffectual in Hungary. The plaintiffs in the Germany case did bring a claim in a tribunal that was set up to settle these kinds of claims in Germany, but they lost. And so then they brought their suit in the United States courts. The second issue in the case, and this is in the German case only, the second issue is whether that expropriation exception under the FSIA even applies. Now, what the plaintiffs say here is that when the Nazis stole their art, that was part and parcel of the Nazis' genocide, the Holocaust, right? And it's the genocide that violates international law. So even this, what the government refers to as a kind of domestic taking, even this purely domestic taking was part and parcel of the violation of international law, that is genocide. And the government says, no, that's not what was going on in this case at all. This was a purely domestic taking where we, the government, will acknowledge we took this property, but it wasn't a violation of international law. And so therefore the government doesn't fall under a sovereign immunity exception under the FSIA. Those are the two big issues in the case. Now, these cases share that characteristic with the Nestle case that you described. To what degree are US courts going to be able to hear cases that allege violations of international human rights?
So how do you see the court playing this out? What's your prediction hat for this one?
Oh, I mean, predictions are always so tough in these cases, right? But I gotta say, the Supreme Court has been on kind of a steady march in the context of the ATS to basically rule domestic jurisdiction out in international human rights cases. And if I had to lay a wager, I think I would say that that's probably going to happen in the FSIA cases as well. What do you think, Kathy? I mean, do you share that assessment?
Yeah, I think I do. And I think it's a really interesting commentary, because when you look at the language of these statutes of the FSIA or the ATS, it's pretty broad language that seems to go along with this very, anyone who's been injured against the laws of nation, come get help here in American courts. And as you said, this has slowly sort of been, the courts have been saying, no, we're not, this isn't our role. Without more, that you can't simply anyone from across the globe can't come here to get a remedy. There has to be more. There has to be a reason that the U.S. courts are getting involved here. And I think you see some competing interests here. There's obviously the desire to ensure that human rights violations anywhere in the world are dealt with, but there's a competing desire to ensure that the U.S. courts are abiding by their own rules and are following the correct procedures, and that you don't have courts getting into sort of foreign relations battles.
Yeah, I think that's exactly right. And on that point, I think the way the court sees it, or is likely to see these cases, is involving serious separation of powers issues. Should the courts be poking their nose into areas of foreign affairs? Or should that be left to the executive? They potentially encompass a lot of different kinds of claims. Should the court go ahead and recognize those causes of action and jurisdiction pursuant to those statutes, or should it wait for Congress to grant it more specific jurisdiction in particular cases? I think what some might say is, well, look, Congress has already done its job. It's already written these statutes quite broadly. The court should just take these cases up, right?
Yeah, there's a reason it's broad language, for sure.
Yeah, exactly. Hey, Kathy, let me ask you. So what do you think you do with these cases in a classroom?
I think you dig into some of these issues that we've been talking about. I think you could do a really interesting simulation where you have students actually draft the statutes. So throw out what's there and ask students with, you assign competing NGOs, senators from certain states, someone arguing on behalf of a court, the Judges Association, and ask them to do a mock congressional hearing on what the statute should look like. How should this be formed? Should it be broad? Should it be specific jurisdiction? What should it look like? And what are the competing interests here? I think is one really interesting way to have students sort of dig into the issues themselves. How about you, Steve? How do you deal with some of these international human rights with your students?
Well, I love that. And what your suggestion then, I think, naturally includes is a discussion about whether the courts ought to be hearing these kinds of cases at all. And of course, the majority on the Supreme Court seems to be moving in the direction of no for some of the separation of powers issues that we described. But I think there are good arguments why the U.S. courts should assert this kind of jurisdiction. And if you look globally, that's what courts are doing in other countries as well. And so I like to think about these questions as domestically as access issues. Should victims of international human rights have access to justice in the U.S. courts, which I think is both an access question and a separation of powers question. But then also thinking about this globally, what are other countries doing? How are they using their jurisdiction of their domestic courts to protect international human rights that both touch on their country, but also international human rights that
Well, it'll be interesting to see what the court does. And as always, hopefully you and I can come back to this space and review argument and decisions once they start rolling out, which should be any day now.
Indeed, indeed. Well, thank you for having me, Kathy.
Oh, of course. Thank you for making the time. And thank you to our audience for joining us once again.